I want to introduce the speaker for today. Dr. Luongo is Associate Professor of History at Northeastern University. I knew I was going to make that mistake. She got her PhD at University of Michigan. As a Spartan, I was willing to overlook that. And she has several books out. Her first book on witchcraft and colonial rule in Kenya is from Cambridge University Press. She has another book that she co-authored with Matt Caratanuto on Obama and Kenya from Ohio University Press. She's published articles in the Journal of African History, History in Africa, African Studies Review, the International Journal of African Historical Studies. So that being said, I'll try to keep it short. I could go on and on, but I'm going to turn it over to Dr. Luongo for her talk today. So you have the floor.
Great. Thank you so much, Todd, for that really kind introduction. And I am thrilled to be here with you today, even in a virtual space, to discuss my new book project on African witchcraft and global asylum seeking. And I very much look forward to the Q&A once I finish my talk. So I'm going to start today by just talking a little bit about refugee status determination generally. And then I'll move into talking about specific cases in which African asylum seekers have made claims about witchcraft as a grounds for refugee status. So the question of who counts as a refugee is of course a pressing concern in the contemporary world. But determining who counts as a refugee is not so easy as it might initially appear. So popular understandings assume that anyone who flees violence or severe hardship in their home country and seeks sanctuary in another counts as a refugee. But in fact, refugee is a precise and highly circumscribed legal status. Potential refugees, asylum seekers, must first make claims for refugee status under the 1951 UN Convention and Protocol relating to the status of refugees. And the convention is the core legislation laying out who can be designated as a refugee, the rights of refugees, and the obligations of refugee receiving states. So as part of their claim, asylum seekers must demonstrate the absence of state protection from the kind of persecution they have suffered or fear suffering in the future in their home country. And these claims are adjudicated by immigration authorities in the country where the asylum seeker has sought sanctuary and protection. So if these claims are successful, then the asylum seeker becomes a refugee with a right to remain in the country where they've sought sanctuary. If the claim fails, the asylum seeker has a right to appeal. And if, in turn, the appeal is unsuccessful, the asylum seeker is sent back to their country of origin. So that's just the kind of nuts and bolts of refugee status determination generally, the international instrument that governs it, the kind of basic steps. So my talk today is drawn from my new book project, Border Crossing Beliefs, African Witchcraft and Global Asylum Seeking. And this is a work of transnational, legal, anthropological, and policy history. And it analyzes the nexus of witchcraft, violence, and asylum seeking. So how did I get interested in this topic? Well, it grows out of a chance conversation that I had with a colleague at the School for Oriental and African Studies in London a few years ago. And he was a noted anthropologist of witchcraft, and he expressed his wonder at the increasing number of calls that he and his fellow Africanists were getting from asylum attorneys who were looking for expert witnesses to testify about their African clients' witchcraft allegations. And so I shared his fascination with this, and shortly thereafter, I began researching witchcraft-based asylum cases. So I started putting together a body of sources about asylum seeking in a world with witchcraft. And this took me on physical journeys to archives and law libraries in the US, in the UK, also in Switzerland. And this introduced me to source bases that are not commonly used by historians. So things like the digital archives of immigration regimes in the global north, the research databases of various UN organizations. And this also took me on an intellectual journey as well. So I researched the nuts and bolts of asylum legislation, of immigration case law, refugee status determination processes across 3 refugee regimes in the global north. And so what I found really astonished me. I found more than 40 cases in which asylum seekers coming to Canada, the UK, and Australia from an array of countries across Anglophone Africa had made claims that being accused of witchcraft or targeted with witchcraft should make them count as refugees. And I was also really struck how the demands of the law flattened asylum seekers' narratives of witchcraft violence. These were stories that I understood based on my previous research into the historical ethnography of African witchcraft. These stories would necessarily be much more layered, much more dramatic, much more nuanced than they appeared in asylum records. And I was really intrigued by the parallels between the colonial era narratives of witchcraft violence that I knew so well from researching my first book, how these narratives of witchcraft violence interacted with the law, and the narratives of witchcraft violence in law contained in contemporary asylum records. So both of these sets of records, the colonial and the contemporary, reflected profound intellectual and discursive struggles. Africans who had been brought up on witchcraft-based charges in colonial courts, and Africans who were making asylum claims before immigration bodies in contemporary asylum settings, both struggled with how to express the real perilousness of living side by side with witches to legal authorities who believed that witchcraft beliefs and practices had been educated and legislated out of existence in the 18th century. In fact, Britain's 1735 Witchcraft Act didn't even outlaw witchcraft per se, but only the pretense to practicing witchcraft or sorcery. So colonial legal authorities and contemporary asylum officials both struggled with making sense of the apparent persistence of witchcraft violence and with the quote unquote reasonableness of believing in witchcraft. Finally, I was intrigued by the demographics of the African asylum seekers who were making witchcraft-based claims. So they came from places as diverse as Nigeria, Ghana, Gambia, Anglophone Cameroon, Kenya, Uganda, and Tanzania. And the makeup of this group challenged the typical imaginary of the refugee from sub-Saharan Africa as poor, uneducated, and rural. In contrast, the majority of asylum seekers I encountered were urban, educated, and relatively well off. The group's composition also challenged the notion that women are the primary victims of witchcraft violence. And instead, men and women both sought to escape witchcraft violence in fairly equal numbers. So analyzing these witchcraft-based asylum cases and situating them within their deep legal, anthropological, and historical contexts provides a key space to better understand how the law interacts with culture and the global reach of local violence. So now I'd like to share some of the numerous stories that I've collected about asylum seekers coming from across Anglophone Africa who have claimed refugee status in the global north because they've been accused of witchcraft or victimized by witchcraft. So let's turn to the facts of a few of these cases. So in 2010, Adeowefu, a Nigerian woman living in the UK, sought refugee status on the grounds that her abusive husband, from whom she was estranged, had labeled her a witch. He had informed their family, their neighbors, and the congregation where he was a pastor in their home state of Edo that she was a witch, thus spreading anti-witchcraft animus against her. And he threatened to take her back to Nigeria and kill her because of her witchcraft. Around the same time, a Nigerian man, Nnamdi Ojukwu, applied for asylum in Australia. He applied on the ground that his fellow villagers had accused him of witchcraft and tortured him on 2 occasions. Village elders had agreed to kill him and had already been hunting him across Nigeria. A few years earlier, Sarah Gideon Makope, a woman from Tanzania, claimed asylum in Canada. She explained that her estranged husband's family belonged to a clan that regularly practiced witchcraft against more educated and prosperous members of the extended family like her. They would certainly kill her if she were returned to Tanzania. So asylum records, such as the cases I've just summarized briefly here, provide a rich new body of sources through which to explore social worlds, supernatural situations, and state-society relations in contemporary Africa. They also offer important evidence about how and why witchcraft persists as an engine of violence in the contemporary world. But the importance of these records isn't just confined to the creation of new knowledge about Africa's past and present. They also shed significant light on the bureaucratic processes, the legal reasoning, and the types of knowledge that go into determining who counts as a refugee. So the asylum seekers like we've just met here make their claims to refugee status under the membership of a particular social group category of the UN Refugee Convention. Some asylum seekers assert that accused witches constitute a particular social group, while others maintain that victims of witchcraft make up a particular social group. Such claims are possible because in recent years, asylum authorities have been increasingly willing both to interpret membership of a particular social group along cultural lines and to recognize how persecution can originate in cultural practices and beliefs. Witchcraft-based asylum cases provide a fruitful terrain to explore how cultural understandings, or in many instances, misunderstandings, complicate the process of determining who counts as a refugee. So ordinarily, asylum seekers must convince immigration authorities simply that if they're returned to their home country, they will be subjected to the kind of persecution that they claim to have suffered already or fear suffering in the future. But asylum seekers making witchcraft claims, however, have to convince asylum authorities not only that they have been or will be persecuted, but also that the kind of persecution they fear exists, that witchcraft is a social fact and a lived reality in their home countries. So asylum seekers who have little to no familiarity with witchcraft and who are culturally predisposed to discount claims about witchcraft face a central dilemma. How to assess claims about a phenomenon that they don't recognize as real, while at the same time acknowledging that the majority of people in the asylum seeker's home country embrace its reality. So close readings of cases like Uwefu, Ojukwu, and Makope then call into question the usefulness of expanding the interpretation of particular social group along cultural lines if adjudicators are ill-equipped to assess culture-based persecution. These cases also indicate how the deep legal history of the absence of state protection from witchcraft violence that forms a really crucial backdrop to asylum seekers' claims is neglected as adjudicators struggle to come to terms with these unfamiliar practices and beliefs. Okay, so I've been saying the term witchcraft a lot already in this talk. So what am I talking about when I talk about witchcraft? Well, in my earlier work, I've defined witchcraft as an embodied capacity, an object or a practice that mobilizes an invisible supernatural power to harm the person, psyche, property, or kin of another. And we can think of witchcraft violence as taking two forms: witchcraft acts and witchcraft accusations. So victims of witchcraft suffer bodily, psychological, and/or financial harm after being attacked with a malevolent supernatural power. People accused of practicing witchcraft, that is, of deploying malicious supernatural power, are also at risk to their lives. So we can think of the witchcraft accusation as a harmful speech act, as a mode of epistemic violence that frequently gives rise to physical violence against the accused witch, often resulting in their death. So these descriptions of witchcraft and violence are ones that I maintain most Africans, including asylum seekers, would recognize. And further, witchcraft does important analytic and discursive work within African societies. So it answers the intertwined questions of why me and of why you, but not me. So in recent decades, the dramatic, destabilizing socio-political and socioeconomic changes wrought by globalization, neoliberal capitalism, and development have made these questions particularly urgent. Ultimately, what matters is that people across the African continent are convinced that witchcraft is on the upsurge, and that these convictions hold concrete consequences for everyday life. So one result, of course, is the introduction of witchcraft into the global arena of asylum. In short, at the same time that the dangerous experience of living in a world with witches, to borrow Adam Ashworth's phrase, has become increasingly fraught, the expansion of the particular social group category along cultural lines has created a space for new categories of asylum seekers to emerge: accused witches and victims of witchcraft. So numerous stories of dislocation and distress, of fear and flight driven by witchcraft violence can be found in the asylum decisions that are handed down by immigration authorities in Canada, the UK, and Australia over the last 20 years. So these three countries resettle high numbers of refugees and share a British common law heritage. Decisions in witchcraft cases form the evidentiary core of my new book project, and they offer, to borrow the words of Benjamin Lawrence and Gayla Ruffer, rich documentary archives that are tethered to discrete legal context. So these asylum decisions incorporate an array of information. They reference immigration law and cite relevant passages. They refer to asylum jurisprudence. They quote transcripts where we might encounter a snippet of the asylum seeker's voice or an expert witness's remark. And they include extracts from the evidence used to support or to contest an asylum seeker's claim. In particular, they include country of origin information reports, NGO reports, and media reports. So, thinking with Bruno Latour's legal ethnography of the French Council of State, I've aimed to make these decisions ripe for use, by establishing the bureaucratic processes and the evidentiary demands that wove them together. And to borrow Latour's words, by keeping the, quote, intellectual and cognitive foundations of the law in mind, unquote. So, despite having a shared British common law history and accepting comparable numbers of asylum seekers annually, Canada, the UK, and Australia have deeply divergent processes for determining who counts as a refugee, and very different approaches to cultural persecution. So, analyzing cases from these three countries side by side does important analytic work. It draws out significant differences in how each country determines who counts as a refugee. But at the same time, it demonstrates the common challenges that asylum adjudicators face. Namely, the challenge of reconciling the asylum seeker's unfamiliar lived experience with Western sociocultural expectations, and the challenge of accommodating claims about supernatural harm within evidentiary-based legal systems. So if we read across these refugee regimes, we underscore how procedural demands in each country's process shape the ways that asylum seeker stories are told and understood. And crucially, it reveals the culture of disbelief that surrounds witchcraft-based asylum cases, no matter how receptive or resistant a particular regime is to refugee claims rooted in culture-based persecution. So let's return now to the stories of Ade Owefu, Nnamdi Ojukwu, and Sarah Gideon Wakope, and examine them in some more depth. Ade Owefu arrived in the UK in 2005 with her husband, who was on a student visa. Owefu herself was well educated, having trained as a math teacher. When she lodged her asylum claim in 2010, she had been estranged from her husband for some time and had been raising their 3 young children on her own. Her case underscores how adjudicators who read the same quote unquote objective country of origin information can nonetheless arrive at completely different conclusions about who counts as a refugee. So asylum seekers like Owefu, who claim refugee status in the UK, are asking that the Home Office, the department of the British government that has ultimate authority over asylum seekers, recognize them as refugees. So at her initial asylum interview with an immigration officer from the Home Department, Owefu explained that her husband had abused her physically and psychologically. This abuse culminated in accusations of witchcraft and threatening to take her back to Nigeria and kill her there because of her witchcraft. So Owefu's husband had told their family, their neighbors, members of the church where he was a pastor in Nigeria, that she was a witch. Owefu explained they would support her murder. Hunting witches, she explained, was common in her home state, and the reach of her husband's congregation was quite extensive. So her initial refugee claim was rejected. The decision record doesn't tell us the grounds for this rejection. Owefu next appealed to the first-tier tribunal, and this is the branch of the UK court system responsible for hearing first-instance asylum appeals. And she reiterated her story to the first-tier tribunal. So the judge of the first-tier tribunal relied on a country of information report about Nigeria. This report had been produced by the Home Office's Country of Origin Information Service. The report described domestic violence in Nigeria as being widespread, as being socially acceptable, and as being a matter in which the police normally did not intervene. So this evidence underscores how Uwefu's experience of domestic abuse was by no means unusual. The report also characterized the belief in, as the report put it, ghosts, juju, charms, and witchcraft as being prevalent and widespread, even among Christians. It explained, quote, "The fear of being the victim of other people's attempted manipulation of supernatural forces is very real," unquote. So the country information here suggests both that Uwefu's experience of being accused of witchcraft would not be uncommon in Nigeria, and it explains how such an accusation could be leveled by her husband, a pastor, and supported by their kin, their neighbors, and their congregation. So the first tier tribunal decided that because of her husband's accusations of witchcraft, there was no place in Nigeria where Uwefu could live safely and openly. Uwefu was a refugee. But it is not only asylum seekers who have the right to appeal. The Home Office can also appeal a decision to the upper tribunal, a higher court. It exercised this option in Uwefu. The Home Office's representative challenged the lower court's decision. It challenged the decision on the reading of the country evidence. The representative for the Home Office argued that evidence did not indicate that Uwefu would be at risk throughout Nigeria. The judge of the upper tribunal concurred with this reading. He went so far as to assert that if Uwefu were sent back to Nigeria, she would be, quote, "better off than many women in Nigeria," unquote. Uwefu was not a refugee. So taking the last avenue available to her, Uwefu turned to the Court of Appeal. The appellate court concurred with the first tier tribunal's reading of the evidence. Uwefu did, in fact, face persecution in Nigeria due to her husband's accusations of witchcraft. Uwefu was once more, and finally, a refugee. Let's turn now to the story of Nnamdi Ojukwu. In 2012, Nnamdi Ojukwu applied to Australia's Department of Immigration and Citizenship for refugee status. He claimed that members of his village community had accused him of witchcraft and had subsequently tortured him on 2 occasions. The elders in his village had agreed to kill him, and they had been pursuing him across Nigeria even after he fled his village. So Ojukwu's case underscores how even if asylum authorities can be convinced that there's a generalized risk of witchcraft violence in the asylum seeker's home country, they remain reluctant to recognize individual asylum seekers' experiences of witchcraft violence as grounds for refugee protection. Determining who counts as a refugee in Australia begins with an intensive paper-based exercise, followed by a series of oral and documentary retellings of the asylum seeker's experience. And these narratives are offered across multiple legal settings. So in the packet of materials that Ojukwu submitted to the Immigration Department, he contended that he had been beaten, he had been hung from the ceiling by community members who had accused him of witchcraft. And he submitted photos of the injuries that he had sustained as well. The immigration officer rejected Ojukwu's claim that he had been accused of witchcraft out of hand. Ojukwu then appealed to the Refugee Review Tribunal. This is a statutory body that reviewed the merits of decisions made by the Immigration Department. So Ojukwu submitted a written declaration in advance of his hearing. In labored English, he wrote, quote, "I was accused of being witchcraft. That leads to community's elders from my village to tortured to abused, including hanging legs from the ceiling. And the elders and young men started throwing objects on me. I almost died during the beating I received from the communities that accused me of witchcraft," unquote. He added that he had sought protection from the local police, who had informed him that witchcraft was a community matter in which they could not intervene. And they suggested that Ojukwu leave the area. So Ojukwu fled to Abuja, but his accusers found him there. They attacked him with a cutlass, as he put it, or a machete, and forced him to return to the village where he was again tortured. He explained that ultimately a young neighbor took pity on him and helped him escape. So, giving oral testimony at his hearing before the tribunal, where he was supported by an advocate, Ojukwu was able to offer a much more complete narrative of his troubles. He explained that after his cousin died in a car crash, villagers consulted an oracle who named Ojukwu as the witch who had been responsible for the accident. Up until this incident, Ojukwu had not encountered any difficulties in his community. He was aware, however, that village elders had been envious of his father's landholdings, and he read the witchcraft accusations as a means to deprive him of rights to his father's property. After this initial witchcraft accusation, Ojukwu was blamed whenever misfortune befell the village, even after he had fled to Abuja. He emphasized that witchcraft was serious in Nigeria and explained, quote, "If something bad happens, they will say someone is a witch," unquote. Ojukwu's advocate presented country information about witchcraft in Nigeria and focused on the lethality of witchcraft accusations and the logics of witchcraft beliefs. In Australia, he explained, a car crash like the one that killed Ojukwu's cousin would be considered a simple accident. In Nigeria, most people would look for someone or something to blame. Further, state protection was not available because the police also feared witchcraft. The tribunal was willing to recognize that witches constituted a particular social group under the Refugee Convention, and also that people perceived to be witches constituted a particular social group in Nigeria. It did not accept, however, that Ojukwu was a member of this group. The tribunal found that the testimony that he had offered across multiple documentary and oral retellings was too vague in its details. For instance, Ojukwu had been vague about the identity of the oracle who had named him as a witch. He was unclear about precisely which village elders had made up the mob that beat and tortured him. The photos that he submitted showed that he had been tortured, but not why, when, or by whom. The tribunal denied his claim. Ojukwu was not a refugee. The documentary record does not indicate whether Ojukwu appealed this decision to the courts, but had he done so, he would have likely faced the same kind of skepticism, given the stringency for which the Australian refugee regime has become notorious. What about the story of Sarah Gideon Makobe? When Sarah Gideon Makobe sought asylum in 2005, she applied to the Refugee Protection Division. This is the arm of Canada's immigration system responsible for determining refugee status. In her initial written submission, she explained, quote, "The region of Mbeya, where our families live, is well known for its practices of witchcraft, sorcery, and human sacrifice. My own parents were educated by missionaries, and we are Christian, and we do not participate in such sorcery. But to us, witchcraft and sorcery are very real and a very evil power. I discovered that in my husband's family, the belief in witchcraft and sorcery has become quite common. A desire for wealth, for power, for fame has led people from my husband's clan to become involved in killing people for wealth and power, unquote. So strange deaths and disappearances had dogged wealthy and educated relatives in Mokope's husband's natal and extended family. Mokope feared that if she were returned to Tanzania, she would be the next prosperous family member whose body would be used as part of witchcraft acts intended to generate wealth. So Mokope's case highlights how immigration authorities can fail to comprehend how an imperative to practice witchcraft can be channeled into procuring material gains. So following standard procedure, Mokope appeared at a hearing adjudicated by an officer of the Protection Division. In advance of her hearing, she submitted country evidence that outlined the scope and scale of witchcraft violence in Tanzania. Mokope testified orally to the same facts and to her own experience of them. So the officer was willing to accept that there was a widespread belief in witchcraft throughout Tanzania, but only that it led to the killing of suspected witches. The officer also rejected Mokope's testimony that she had sought police protection on multiple occasions and had been rebuffed by the police. Rather, the officer argued, documents showed that practicing witchcraft was considered a criminal offense and that the police had been involved in investigating witchcraft-related killings. Because Mokope had not provided evidence that law and order had completely collapsed in Tanzania, she had not demonstrated that the state could not protect her from her husband's family. Mokope's kin aimed to persecute her in what the officer termed a, quote, search for wealth, unquote, not because of an imperative to practice witchcraft, was driving them to harm her. So Mokope next appealed to the Federal Court of Canada. Here she was supported by an attorney who challenged the officer's interpretation of the country evidence. He explained that the officer's understanding of witchcraft was topsy-turvy, focusing on the killing of suspected witches at several points. The officer had misconstrued Mokope's claim, believing her to be afraid of being suspected as a witch, when in fact her claim was that others would practice witchcraft against her. This misapprehension, in turn, muddied the officer's understanding of the lack of state protection. The fact that Tanzanian police had been involved in investigating the murders of accused witches had no bearing on people like Mokope, who were the targets of people who practiced witchcraft. Furthermore, there was a good deal of country evidence, but state protection was generally alarmingly poor in Tanzania because of corruption. Yet, despite these arguments, the federal court supported the officer's approach to the evidence. The judge found that if Mokope's relatives desired to kill her, it was not out of an imperative to practice witchcraft, but rather simply in pursuit of wealth. She was not a member of the particular social group, victims of witchcraft, but rather a victim of ordinary greed. Mokope was not a refugee. So the cases of Adeowefu, Nnamdi Ojukwu, and Sarah Gideon Mokope show the extent to which determining who counts as a refugee depends on the knowledge and interpretation of individual asylum adjudicators. This highly subjective decision-making is even more problematic in witchcraft cases, where the persecution at the heart of the claim to refugee status is so outside the experience of individual authorities. So while country evidence is meant to fill these gaps, the incredulousness that adjudicators bring to assessing witchcraft claims restricts its usefulness. The Refugee Convention has long been criticized for constructing persecution too narrowly and from a Eurocentric perspective. A broader interpretation of a particular social group along cultural lines was intended to help remedy the convention's limited scope. But as we've seen here today, the experiences of asylum seekers like Adeowefu, Nnamdi Ojukwu, and Sarah Gideon Mokope call into question the usefulness of expanding the interpretation of a particular social group to consider culture if adjudicators are ill-equipped to assess culture-based persecution. So these asylum cases at the heart of my project offer an important avenue to access new knowledge about Africa that is being produced in a variety of legal settings outside the continent. But my research also indicates that a central part of the story of seeking refuge from witchcraft violence is missing. And that is the deep legal history of the absence of state protection from witchcraft acts and witchcraft accusations. Close readings of case law and jurisprudence generated by the continent's Supreme and Appellate courts from the early 20th century into the present day reveal countless narratives of witchcraft violence that parallel those of contemporary asylum seekers. These records point to the intractability of witchcraft violence and the concomitant failure of states, both colonial and post-colonial, to eradicate or at least curb it. It would seem obvious that the absence of state protection is intimately linked to the effectiveness of the state's legal system. Yet, immigration authorities hardly ever engage with the relevant country-specific legislation, case law, and jurisprudence in assessing witchcraft claims. In the rare instance that they do, they often fall victim to magical legalism. The idea that, to borrow Stanley Cohen's words, if an act is prohibited, then it effectively does not occur or only occurs as an anomaly. So we saw this at work in the officer's claim that Mokope was not at risk from witchcraft persecution because practicing witchcraft is illegal in Tanzania. Because persecution stems in no small part from the lack of state protection, it's crucial that immigration authorities understand the deep legal background of the state's failure to protect, whether that failure obtains from the absence of relevant law or the unwillingness or incapacity to enforce existing law, rather. So reading this ethnographic information and legal history together can help avoid the pitfalls both of misunderstanding culture and inviting magical legalism. Overall, as the bounds of a particular social group continue to expand along cultural lines, so too must the knowledge for effectively assimilating asylum seekers' claims about culture. Thank you very much.
Okay, thank you, Katherine. We have about 45 minutes left for question and answer, so I will take questions and comments from the floor. Louise, I see you've had your hand up for quite some time.
Hi, Louise.
Want to go ahead, Louise? Might take a moment to shift over as a panelist.
My camera doesn't seem to be working.
We can hear you fine, though.
Yes.
Okay,
Great.
okay. No, I mean, thank you for that. Let me see if I can get, why would I want the camera? Oh, there we are.
Hi.
It made me very nostalgic to see Todd's study, see Todd's office. No, I really, really appreciated that. And I have a bunch of kind of off the wall questions as usual.
I'll see what I can do.
Yeah, no, I mean, having worked with political refugee files, you know, at another juncture, you know, in the 60s, if you have, people are very aware of the status. And you know what you can claim where. So refugee, asylum, and they tailor their stories. I mean, they work them out. So this is really my question. I'm sorry to have prefaced it so badly. Do you see kind of a coherence in the stories that are not just necessarily about experience, but about people seeking asylum, giving advice to others about what's the winning story? What's the story that gets you what you want?
Mhm.
Am I making sense?
Oh no, that makes perfect sense.
Well,
Yeah, and I mean that's really the question that gets applied to every asylum seeker's narrative, no matter which of the UN refugee criterion that they're seeking asylum under. So of course we have to assume that these stories circulate, what is effective circulates, but the way in which they're coherent to me is through my knowledge of experiences of witchcraft and the absence of protection from it, the social dynamics that exist on the continent. So I think these stories make a lot of sense based on what I know from the context that they're coming from. And I mean, nobody can really say what an authentic story is and what it isn't.
I'm sorry, I didn't phrase it right. I mean, but the stories are being told to make sense to a certain audience,
right?
Which is not scholars.
No.
And I guess I'm intrigued that people telling these stories don't have a sense of playing down what Westerners think of as exotic or you know, is I guess they don't seem to have a sense of playing down certain elements because what makes a story credible, and what is the bridge too far? That's my question.
Okay.
Yeah, sorry.
Oh yeah, no, not at all. So, you know, something I find fascinating and disturbing about asylum adjudication is the degree to which it hinges so much on the predisposition of the individual adjudicator at every stage. So the UNHCR offers guidelines for assessing credibility that asylum adjudicators are supposed to conform to when they're assessing testimony. So what asylum adjudicators look for generally is consistency across the different tellings of the asylum seeker's narrative. When they're in a hearing, they look very much for the kind of like affective state, for the way in which the asylum seeker presents their narrative. But then, of course, there are all of these different mediating factors. So whether or not the asylum seeker has representation really goes a long way in establishing their credibility. Whether or not an asylum seeker has a competent interpreter also goes a long way in establishing their credibility. So it's a bit hard to tell about the asylum seeker's sort of internal decision-making process about how to narrate their story, because it passes through so many different levels of mediation, sometimes with advice, sometimes without advice. And for the asylum adjudicators, it doesn't seem to be so much a matter of the details of the particular witchcraft experience, but really just how on board the adjudicator is with entertaining the notion of witchcraft at all. And I would say that this is not going to be surprising to anybody, but the cases in which people say that they've been accused of witchcraft are much more successful than cases in which they say that witchcraft has been deployed against them in some way. And of course, that's because there is tangible evidence of the lynching of alleged witches that asylum courts and tribunals can assimilate pretty easily.
Thank you. Sorry.
Yeah, thank you for your questions. It's nice to see your office too.
That's my home. Yes.
Okay, the next question or comment from James Asegbe. Go ahead, James.
Hi, James.
Hello. Can you hear me?
Yes.
Yes.
Fine.
Okay. Sorry. Part of my the first part of my question was going to be is sort of what Louis asked, because I sat there and I was pardon me, I was just shaking my head like, this is a good story. Like, yeah, people have to tell these stories nicely, right? But the first half of my question is a really naive one. Taking your definition, I'm just curious. When you started with witchcraft is an embodiment. Definition, I was wondering what would be the difference between is a belief of an embodiment with witchcraft is an embodiment?
Yeah, so the way that I would define witchcraft really broadly, to, of course, take in all of its different permutations, is that it's an embodied capacity, or an object, or a practice. And necessarily, people believe that it is all of those things, some of those things, none of those things. But I think that defining it as an embodied capacity, so a capacity to exercise a kind of malevolent power from your body, that it is a certain kind of practice. So you engage in different kinds of activities, and those can either be mobilizing your body, or it can be using an object that has been imbued with a supernatural power that you then use in a particular practice. Kind of covers the gamut of the different permutations of witchcraft. And something I found really interesting in these cases is there's very little time and energy devoted to explaining what witchcraft is beyond the kind of simplest definition that it's the marshaling and using of a malevolent supernatural power that can be affected through the body, through a practice, or through an object. And it's even very rare in the cases that we see any of the vernacular terms for witchcraft and the kind of parsing of what witchcraft is in a local setting appear in these cases.
Okay.
Okay, we have a question or comment now from Anita Spring. Go ahead, Anita.
Hi, Anita.
Should be coming shortly.
Wait a second.
It's okay. Gives me
Okay, there we go. Hi.
Hi, Anita.
Okay, so I had the pleasure of listening to something like 100 cases, not all witchcraft, but many of them were, at both my local village level in Zambia, and then going to the government court in the area and hearing some of them again.
Oh, fantastic.
Night and day. I have them all written out so I could send it to you, I suppose, for your analysis. I didn't get that far. So I have a few questions. Were there any witnesses called by the defendants? What do we the person who brought the case?
The claimant.
The claimant.
Yeah.
So did the claimant have any witnesses? And would those witnesses have been family members, or could that have been somebody who was a diviner or a healer who dealt with witchcraft? you know, they could have explained things. I'm fascinated by the fact that, and I understand this intrinsically from listening to these cases, that they didn't bring people along to really flesh out the explanations, because it was so linked to the cultural issues that everybody thought everybody knew it. And nobody would have thought that. And I don't know if they brought an attorney, you know, from Australia or Canada or the UK on their side to kind of help them to bring out those kinds of details that might have made a difference in the case. So that's my first group of questions. And the second one was that, do you have any quantitative data on people who succeeded or did not succeed, so we can understand how prevalent this might be, or how they're really, the data show that most of them don't get the refugee status. That, I mean, your cases, none of them got the refugee status.
Adi finally got it in the end.
Oh, we finally got it.
Right, yeah, but after she went through like every possible layer.
Oh, okay. Yeah, okay, because then the final question on her was going to be, did she go back and was she killed or did harmed in some way? So, and then in terms of the ones who didn't get it, were they actually deported back to their countries? And was there any follow-up? Did anything bad happen to them? It might not have been death, but something bad. So those questions.
Okay, great. Thank you. Those are wonderful questions as well. So when you were asking about witnesses, you were asking if the refugee claimant had witnesses at the various hearings. Is
Yes.
that
Yes.
so? When the refugee claimant has a witness, it's typically an expert witness. So somebody like us, who the asylum seeker's attorney would hire to really do the kind of work of cultural translation between the asylum seeker's narrative and the court. So it's not the case where there would be witnesses from the asylum seeker's home country, from their life, who were invited into these proceedings. And a lot of that has to do with just the mere practicality of it.
Sure.
And also, it's not guaranteed that an asylum seeker will have representation. In many cases, they do not. And so it's not something that's required by any of the immigration regimes that I've discussed. And so when there are expert witnesses who testify on behalf of the claimant, that's a case where the asylum seeker has been able to get legal representation, and that has been organized by the asylum seeker's attorney. So with the quantitative data question, so what I've been looking at is the cases that have been made publicly available in the databases of these different immigration regimes. And so the regimes tend to publish the cases that are notable for some reason in their view. And so what I found from the cases that I've collected is that claiming that you've been accused of witchcraft is much more successful than claiming that you've been targeted with witchcraft. But the witchcraft-based particular social group cases are not particularly effective, but the grant rate overall for cases heard under the particular social group criterion is not high, and the grant rate overall is not high. So that would be my answer to the quantitative question. And so what happens to people at the end? So we don't know what happens if they do not receive refugee status, because the cases are anonymous.
Mhm.
So I have named all of the different people I discussed with pseudonyms because in the decision, they're just listed as XXX. So because the cases are anonymous, there's no way to trace what happened to them if their claim was denied. So we can say what happens to asylum seekers generally kind of depends on the country where they've sought asylum. So like in some asylum regimes, there's another layer of appeal against the deportation proceedings, but that's undertaken by a different set of legal authorities. In some places, people just kind of languish in this liminal state for years before they're finally deported. Sometimes the state doesn't make that much effort to find them, to deport them. In other cases, they're like on the next plane. So a lot depends kind of on the proclivities of a given refugee regime.
The ones I saw that were at village level were all settled in various ways. Usually somebody had to pay something to the person who brought the claim, and it was settled right then and there. And you know, then people could kind of work it out afterwards, and there were still people haggling about, well, you really did ensorcel me. You did do those medicines on me, and I'm not going to accept it anymore. And you heard the court's ruling and all those kinds of things. So they got a lot of exegesis out of it. And people could keep their eyes on these people to see if anything happened to them. It's quite different.
Right. And oh, that brings me back to a point I was going to make when you had asked initially about the witnesses. So something I found really fascinating when I started reading these asylum decisions was how familiar all the discourse was from having read so many Supreme Court and appellate decisions. And so in the colonial era, as you likely know, there was a category of expert, the native assessor, who was called into the colonial court to advise the European justices on matters pertaining to culture. And so when I started reading these asylum cases and started reading about the role of expert witnesses, I thought, wow, these are like the modern day native assessors for the asylum court or asylum tribunal. But your experience in Zambia sounds really fascinating.
It was different. That wasn't my main topic, but I got fascinated.
Yeah, but it's everywhere. You can't escape it, right?
It was everywhere.
Yeah.
I mean, the headman of the village got up in a tree one night and started ranting and raving, "We know you witches are out there." And he went on and on and on. And people who lived in the village, I mean, I was right there in the middle of it. Yeah, and people just took all that stuff for granted. But it was modified because it was open.
Right.
It was known. Bringing this up in, you know, other countries on the other side of the world, it's very vague.
That's true. That is definitely true. Thank you so much.
Okay, next question or comment from Ashley Parcells. Go ahead, Ashley.
Hi, Ashley.
Hi, nice to meet you. So I have perhaps maybe 2.5 questions. So first I wonder if you could speak a little bit about, I guess, how many cases you are looking at in terms of the whole project, and what the span of years these are coming from. And in terms of the people who are claiming asylum, are most of them arriving in the country and claiming asylum there? Are any of them previously on, for example, other types of visas and then claiming asylum? And is that influencing how these cases are being heard? And then the final question is, have you noticed for the asylum officials who are observing, kind of adjudicating these cases in the courts, have you noticed any gendered nature of how willing they might be to accept witchcraft narratives depending on the gender of the asylum seeker?
Yeah, So far, I have found around 40 cases by doing research in these databases. And I've used all different kinds of iterations of the term witchcraft to search them. And the span I'm looking at goes back to about 2000. So this is a fairly new kind of claim, but that's because the expansion of particular social group to take in culture-based persecution is also quite new. So that really started with the first FGM cases that were being heard in immigration courts. And the kind of benchmark case is a case from 1996, actually heard in the US, where a Togolese asylum seeker who didn't want to be subjected to FGM had fled and made her claim under the particular social group category. So it's really these FGM cases that kind of blew the particular social group category open to take in culture-based persecution. And it's really a mix of asylum seekers who are arriving in the country and making the claim, and those who are in the country on a different kind of visa. So we saw Adiowefu was already in the UK because her husband was there on a student visa. But the other two asylum seekers whose stories I discussed arrived in the receiving state and made a claim. So I would say that it's more common to see people arriving in the state and making a claim, but it's also not so infrequent that it's really unusual to find people who are in country and making a claim. And in terms of gender, it doesn't really seem to matter whether it's a man or a woman making the claims about witchcraft in how their case is determined. I haven't noticed that there's, like, say, a higher percentage of women being believed, because in our Euro-American concept, we think of witchcraft as something being gendered female, but that doesn't seem to have really weighed in the decisions that I've looked at.
Okay, thanks. Next question from Apollo Amoko. Apollo, are you there?
Apollo, it's been so many years since our days in Ann Arbor.
Hi. Yeah, it's been a long, long time, during which I have lost my eyesight and my hair, as you can see.
Oh my goodness.
Your talk made me very nostalgic, but from a different perspective. And I look forward to catching up more personally.
Yeah.
I have a series of not fully formed questions or critiques or observations. The first is, you did point out that people who say they have been accused of witchcraft are more likely to succeed. And it seems to me that there is a self-evident reason why, because in a sense, one doesn't even have to deal with the epistemology of witchcraft if the accusation triggers predictable violence. But I wonder to what extent there's a sort of throwaway line you made when you're discussing the Australian case, and you reiterated it more expansively when talking to Anita Spring. Most of these applications, for whatever reason, are turned down, and for whatever reason they're made. And I wonder to what extent witchcraft provides a particular specificity in the way these claims are being dealt with, or if this is just part of the latest instantiation of a bureaucratic imperative. I was thinking this is not quite commensurate, but I was once renewing my visa at both the Kenyan and the Tanzanian embassy, and they were simply turning down something like 98% of the visa applications. And the bureaucratic imperative was at some point so irrational that obviously fake applications got through, whereas plausible applications got turned down. So I wonder to what extent one is just talking about a bureaucratic logic that is cynically designed to turn down as many applications as possible, and what is the specificity of witchcraft in that connection. And the third question, which is more of a provocation, I wonder to what extent witchcraft discourse is actually that alien, and whether there is a danger of accepting at face value African radical alterity, because after all, Pentecostal cultures are saturated with demons and all sorts of evil spirits and what one scholar calls violent prayers, and all that mysticism. And Catholicism still does exorcisms, not just in Africa, but also in the West. So is there a certain willful ignorance when people say this is entirely alien, this is another world altogether from the Western world that we are used to? Thank you, and I look forward to catching up.
Great, thank you. Thank you for those questions. Yes, so as I was saying, and as you pointed out, people who say that they're accused of witchcraft have more luck than people who say that they've been targeted with witchcraft. And again, that's because you can point to a kind of tangible, legally assimilable evidence that people who are accused of witchcraft can very often fall victim to lynching. But a lot of asylum adjudicators fail to recognize the kind of pervasiveness of that problem. And they very often will say, as we've seen in the cases here, okay, so we know that that's like a thing that happened, that happens in your country, but we don't believe that it happened to you. So the asylum seeker has this double burden in whatever their criterion that they're applying for asylum under. So first they have to show that the kind of persecution that they have suffered or will suffer exists in their country in the way that they say it does. And then they have to convince the asylum adjudicator that they've had a personal experience of that kind of violence, or that they're going to be at risk of that kind of persecution if they're returned to their country of origin. So very often you'll be reading asylum decisions of all kinds, and you'll see the adjudicator say, yeah, so I believe that kind of persecution is a thing that happens in your country, but I don't believe that you've made the case that it's something that you're at risk for. And so we see in a lot of the asylum cases that sometimes the asylum adjudicators will say, okay, yeah, so accused witches can be at risk of being killed in your country, but you haven't made the case to me that you belong to that group, accused witches, for whatever reason. And that can be how the asylum adjudicator reads the country evidence, what they think about the credibility of the asylum seeker. And yeah, so like this period of the last 20 years definitely coincides with the increasing kind of like crunch around asylum adjudication and the kind of increasing strictures of these different asylum regimes. So there's a bureaucratic imperative that I think underlies every kind of asylum case. There's this culture of disbelief that permeates asylum adjudication in all three of the regimes that I've discussed, Canada being the most kind of open and liberal, and Australia being the most stringent. And so asylum adjudicators, for the most part, in the decisions I read, certainly go into the adjudication process with what Lawrence and Ruffer have called like a hermeneutics of suspicion. And there's also a sense, I think, a kind of like tacit sense about what asylum adjudicators are prepared to deal with and really engage in. And there's a kind of tacit understanding about, okay, we've all agreed that this kind of cultural practice counts as persecution, but we don't agree necessarily about this other form. So like if you're reading decisions today, like FGM is pretty well established as a category of cultural persecution. It's not something that really gets debated. But in the witchcraft cases, it's just very much a function of the individual adjudicators, the lens they bring to bear, the background that they have, how well represented or not the asylum seeker has been. And so I think you make a really good point that, you know, the West is not nearly as disenchanted as we claim to be. But the fact is that we claim to be, and that's a very important claim, I think, in legal settings. So even if people are willing to recognize the enchantedness of the world, the law is not willing to recognize that kind of enchantment. So asylum adjudicators, you know, they may think like maybe they are Catholic and maybe they believe in exorcism, but then at the same time, when they're thinking legally, they think about the legal existence of witchcraft. And so that is something that Western legal systems have worked to legislate out of existence.
Thank you.
You're welcome.
All right, next question or comment from Peter Schmidt.
Hello, Peter.
Give him a second there. There we go. Go ahead, Peter.
Oh.
Thank you. That was really, really fascinating. When I think about the country evidence, right? The country evidence is sometimes really problematic. Who is it compiled by? Usually by political officers and other characters like that in embassies who depend on news accounts that are oftentimes sensationalized. And they use widespread inference as a consequence. So whatever ends up in the hands of these hearing officers is extremely biased according to the perceptions of those compiling the reports. I can think of the sensationalization of witchcraft in Tanzania, for example. Mm-hmm. Every couple of weeks or even a couple of months, there are big headlines about witchcraft in this and such an area. Where if in fact you go to visit that area, people aren't even aware of it, perhaps except in a very specific instance. Mm-hmm. So these reports tend to characterize by region. And I can think of a case in point when we were being briefed on a Fulbright, and we were told not to travel to Western Tanzania, where we were headed, because it's a very dangerous area. You shouldn't go there at all. Mm-hmm. This kind of captures what happens in these country reports. So that's another area in which perception and compilation of information, I think, really merits some really deep inquiry. And Louise was getting at a point, and I think it also came out in Anita's question and discussion about motivation. No, is it simply a good narrative that's going to be more viable, is going to really carry the day? Or is there something going on in the backgrounds of these people that compel that kind of narrative? So I think of certain innuendos and things that happen in the villages where I've lived. And thieves particularly, suspected thieves, thieves uncaught. The rumors begin to spread that perhaps they're witches and they're dangerous. But there's another level too. Thieves are actually caught sometimes and severely punished within the village without involving the police. That is very common.
Oh, sure, of course.
And what are the motivations of that chap from Nigeria? He couldn't name the oracle, he couldn't name the elders. The alternative hypothesis is he was running from something other than witchcraft. Similarly, one wonders about the woman from Mbeya. Is she perhaps simply a bad daughter-in-law and doesn't want to return to that family? And this then brings up a question about, is there then the need for kind of a deeper inquiry, kind of ground truthing to establish motivation? Besides, whether or not a good story works. And have you thought about the possibility that going into these communities and seeing whether or not these are tales that resonate with anybody in this community to establish motivation? That's basically my question.
Great, thank you for that. Yeah, I would agree with you that the country information is really deeply problematic. There's actually an entire chapter in my book where I address expertise and really do a critical reading of the country evidence. So in all the instances that I tracked down the country reports that had been used in the different cases that I've been looking at. And yeah, you're absolutely right that a lot of this country information is really broadly sourced. It's kind of just like this weird mosaic composite of like a news report here and a US Department of State report here, and it's not really coherent. There's no, it's very decontextualized. And so some of the immigration regimes actually have their own country of information bureaus that are research arms of the larger asylum apparatus. And those reports tend to be better than the kind of just like general country reports. And in some refugee regimes, asylum adjudicators can make inquiries to the research arm of the asylum apparatus to do research on a particular question pertaining to the asylum case that they're adjudicating. But they don't have to do that. They don't have to look at country information. The only way that any kind of expert testimony is going to get into a case is if an asylum seeker is lucky enough to have an attorney who gets somebody to testify for their client. And we can't, I think that your question is about the background of people is really, it's a really compelling and important one, because we know that witchcraft gets used to accuse people of a lot of things that aren't witchcraft.
It's a mask oftentimes.
Mm-hmm. It does a lot of work. But the thing is that we can't know about these particular asylum seekers because, again, the cases are anonymous. And we also don't know where particularly they might be from in their country beyond the level of like a state or a province or maybe a city. So there's no way to kind of trace their story back to the level of their community. But so we can only really kind of like read their narratives about against what we know about witchcraft in the general area that they come from. Let me see, you had another question. In the
the way that witchcraft, for example, is characterized in Mbeya, that would take deep, deep inquiry by an anthropologist working for some length of time to establish that it's as widespread as this appears to be in the sensationalized media, which I'm sure that even, the researchers within the embassy would characterize from the reports they have. Nobody wants to travel out to those areas to establish ground truth on this stuff.
Sure. And so if you're a fortunate asylum seeker, maybe your attorney could get you an expert witness who has that deep kind of knowledge, who could testify to the contents of your affidavit or your personal information form and to the general kind of country context that is at work there. And again, I mean, this question of a good narrative or not, I mean, that is just something that we have to apply to every asylum decision that we read. And again, there are all of these different kinds of formal and informal mechanisms that asylum seekers apply to try and assess the credibility of the asylum seeker's narrative.
Thank you very much.
Thank you. Thank you for your questions.
Okay, we are at the 2-minute warning, so I have one more question from Barbara McDade Gordon, and then we'll wrap up the formal part of the session. As I said before, if anyone wants to stay in the room, as long as Catherine's willing to stay in the room, we'll let the chat continue. Go ahead, Barbara.
Okay, thank you, Catherine, for that very informative and interesting presentation. I grew up in Louisiana, so I know something about what voodoo or whatever we called it there. But I was just wondering if it's somewhat exotic, apparently, to the people who are seeing and hearing these cases. And I'm wondering why would these petitioners go that route instead of something that was probably, I don't know, more provable or reasonable to them, such as the woman whose husband, who could have been, her case would have been a victim of domestic violence, or being persecuted, or the other guy being persecuted in his home area. Why would they, come up with this idea about witchcraft, which, unless it's just a big thing to them, but it's not apparently as something that is plausible to the people who they're putting the cases before.
Yeah, so thank you for that. That's a great question. So the reason that people are applying under the membership of a particular social group criterion of the UN Refugee Convention is because that is the criterion that corresponds to their experience of persecution. So the UN Refugee Convention is really narrowly written, and there are only a very few criterion under which one can apply for refugee status. So you can apply on the grounds that you're being persecuted because of your race, your religion, your nationality, your political opinion, or your membership of a particular social group. So if you're being persecuted in a way that does not conform to one of those criterion, then you are out of luck with the UN Refugee Convention. And so people are applying under particular social group, making the argument that accused witches constitute a particular social group in their home country. And a lot of people do make claims, like Adi did, about domestic violence, but for domestic violence claims to be effective, they have to cross-cut with one of the convention criterion. So if they don't, then the person would not be regarded as eligible for protection under the Refugee Convention.
Okay, thank you.
Okay, thanks for that, Barbara. And with that, I really want to thank Catherine for joining us today and everyone who attended in the room. That brings to the end our formal part of the presentation. And again, you're welcome to stay in the room if you'd like. I will move through the list of attendees and make you panelists. And once you're a panelist, then you can turn on your own video should you like. And I'm not going to moderate. This is kind of more like happy hour. So, you know, you will moderate yourselves as your Zoom etiquette that you've learned over the last year has determined. So with that, thanks very much, Katherine.
Great, and thank you so much for having me and for your really wonderful questions. And I'm happy to hang out for a little bit longer. So.
Great, thank you again.